I got it right here.
Number and all that stuff.
I keep your number right in front
Judge,
of
I
you.
think there was a second look from yesterday also, I think Willie Miller, or.
Willie
that
Miller.
was rolled over from yesterday.
That's the city of Fort Lauderdale.
Fort Lauderdale.
So we'll hold off on that, all right?
Okay, perfect. Thank you.
Okay.
Have a good one, Your Honor.
Can you tell Marge that we're doing everything at like, let's say 2:30? How's that?
Okay.
Tell Marge real quick.
I'll tell her.
I'll tell you.
You tell her. City of Fort Lauderdale, 2:30. Ask her to.
It'll be a little bit sooner than 2:30 to
Wait.
get the dental appointment.
Well, can you tell the prosecutor? Can you call them and tell them to be here when you're here?
At 2:15.
Got it.
Thank you, Your Honor. Have a good
Yes, sir. Thank you. Okay, so. Well, I had a professor in law school who used to say, now you first years need to get yourself organized.
Portuguese, you got a Portuguese.
Oh, you're Portuguese. Okay. Where's our second player?
But I have another picture.
Okay, we'll take care of yours real quick. How's that? Nah, you can just hold off on that.
What's up?
Okay, you ready to go, man? Hi, good afternoon. May I see Manuel
please.
Mendonca? Ma'am, do you swear or affirm to translate from English to Portuguese, Portuguese to English, truthfully and to the best of your ability?
Yes, Your Honor.
Okay, good afternoon. There you go. Good afternoon, Mr. Mendonca.
Boa tarde, senhor Mendonça.
Sir, you are charged with domestic violence battery.
O senhor foi acusado de violência
The
doméstica.
court finds probable cause.
A corte concorda que tem causa para fazer essa acusação.
Say, does this gentleman have a criminal record?
Yes, Your Honor. 2011 in Broward, he had a loading and prowling, exposure, and voyeurism.
Okay.
One moment, Judge. Also, it looks like in 2011, a woman sought a order of protection against him.
Okay.
Está me interpretando?
yes.
Ok, em 2011, o senhor, eles estão olhando a sua ficha criminal. Em 2011, o senhor foi acusado de vadiagem. O senhor também teve uma ordem de afastamento. Uma senhora pediu contra o senhor. Tá me ouvindo? O senhor
Já,
tá
tô.
ouvindo? Ok.
Estou
Are you
ouvindo, estou.
currently employed?
O senhor trabalha?
Trabalho, já.
Yes.
What type of work is that?
Qual tipo de trabalho que o senhor faz?
Landscaping.
Landscaping.
Do you have money in the bank?
O senhor tem dinheiro no banco?
Como 500 e tal, $600.
500 something dollars.
Okay. Do you own land or property here in South Florida?
O senhor tem
Não.
imóveis ou uma casa aqui no sul da Flórida?
Não, não tá.
Do you have anyone who can help bond you from the jail today, sir?
O senhor tem alguma pessoa que pode ajudar a pagar uma fiança para o senhor sair da cadeia hoje?
Não tem. Bem, não tem. Tem amigos, né?
I don't have anybody, I have friends.
State, did you have any contact with the alleged victim?
I don't believe so.
No. It is alleged you grabbed a woman, Ana Mendonça, by her neck.
Foi alegado que o senhor agarrou a senhora com violência no pescoço dela,
Pushed her down
No,
with
I know-
your pushed her down with your hand,
que empurrou ela com sua mão
putting your hand on her face, her chest, and her neck.
e colocou sua mão no rosto, no pescoço e no peito dela.
Sir, based on the level of violence, your recent criminal record,
Baseado no nível de violência e também olhando sua ficha
Someone-
criminal recente,
and the fact someone had to have an injunction against you to keep you away from them.
incluindo uma vez que uma pessoa pediu um mandato de afastamento para o senhor se manter afastado dela.
The court will say your bond at $6,500 today.
Então, a sua fiança hoje é $6.500.
The court will order you have no contact directly or indirectly with Ana Mendonça.
O senhor tem um mandato judicial que o senhor não pode ter contato direto ou indireto com a Ana Mendonça.
You must stay 500 feet from her at all times.
O senhor tem que se manter distante, pelo menos 500 pés de distância dela em todo o tempo.
That is where she
Okay.
lives, works, goes to school.
Isso inclui onde ela mora, onde ela trabalha e onde ela vai para a escola.
Or anywhere else.
Ou qualquer outro lugar.
You are not allowed to possess any guns,
O senhor não
firearms, weapons while you're on release.
pode. O
Thank you.
senhor, enquanto está em liberdade, não pode possuir nenhuma arma ou arma de fogo de forma nenhuma.
Tá.
Thank you, sir.
Muito obrigado,
Outra coisa.
senhor.
Ei, outra coisa, eu tinha uma pergunta para fazer. Eu.
Ok, o advogado está explicando que o senhor não deve falar nada sobre o caso.
Ok.
Ok.
Thank you, sir.
Muito obrigado, senhor.
Okay, thank you, ma'am. Good afternoon, everyone. My name is John Hurley. I'm your judge this afternoon. We are in first appearance court. Today is the day this court determines whether or not there is probable cause for your arrest. We're not here for a trial. We're not here to determine whether you're guilty or not guilty. It's not for today. I tell you that because you don't need to tell us what happened. You don't need to explain yourself, defend yourself, make any excuses. Not for today. Save that for your attorney in private. Now, you have the constitutional right to remain silent. Utilize that right at all times. If you give up the right to remain silent, whatever you say can and will be used against you. Also, if you have a private attorney, let me know who that is when you're called up. We'll contact your attorney and let them know that you're in court. Let's see Jennifer Francis, Jennifer Davis,
President of Maine, Your Honor.
Latita Foster. Jennifer Francis. Ma'am, you're here for possession of cannabis and loitering and prowling. All right, are there any, do we have any priors on this?
No, Your Honor.
No? Ma'am, do you still live on 119th Street in Hialeah?
Yes, sir.
Are you working at this time, ma'am?
Your Honor, she's a full-time student at Miami-Dade College. She's studying psychology and apparently getting good grades.
Okay, I'm going to release you on your own recognizance, ma'am. Thank you. How about
Thank you, Your
Jennifer
Honor.
Davis?
We have an argument.
Ms. Davis, you're charged with resisting arrest without violence, and you have a probation violation. Go ahead, Mr. Miller.
Your Honor, I read the probable cause in this case, and the officer saying that she was standing in the road and refused to get out of the road. I don't know how that's obstructing a lawful duty. I guess he has a right to drive on the road, but I don't know that he has a duty to drive on the road. I think she could have gotten a ticket for obstructing traffic, but other than that, I don't think she committed a crime. I would ask the court to ROR her on this case and to ROR her on the probation violation. I don't believe that there's a warrant associated with this. This is just a 948 hold.
Well, it says that she was intoxicated, dancing in the middle of the street in Hollywood at about 1:21 in the morning. It says she was obstructing traffic, and the police officer gave her a lawful order several times to get out of the road, and that she didn't do it. Placed her under arrest.
Is that obstructing a lawful investigation?
I think a police officer
I mean,
probably has a right to investigate why somebody's dancing in the middle of a roadway and asking a person to get out of the roadway. I think
Your Honor, I'm sorry. This is a reach for this charge.
Well,
It really is.
it's not just an investigation, but a lawful duty, obstructing a lawful duty. And certainly I would argue an officer, if he sees someone in the middle of the night dancing in the street, not only has a concern for other drivers, but for that person's own safety. I mean, I can imagine the headline if the officer ignores it, and then she gets run over by a car, and it turns out the officer saw it, but decided, you know what, I don't want to disrupt her good time and let her dance in the middle of the street. Obviously, an officer has an obligation. If
I
he
could
has a
see the
concern.
headline: "Woman dancing in the street, officer ignores it."
gets hit by car.
That's true.
You know, I mean, so
Well, Your
what's
Honor,
the
you know
officer
what?
to do?
Crisis is averted, okay? She's not in the street anymore. I'm asking the court to ROR her and to let her ROR on probation.
Here's the problem.
Let the division judge sort this out.
The problem with that is
$117 a day is not worth keeping her in
Hold on.
custody for dancing in the street.
she's also drinking, dancing in the middle of the street. She was only put on probation 2 weeks ago for possession of cocaine, drug paraphernalia, and prostitution.
Oh boy.
Last year, on a possession of cocaine, she was sentenced to 220 days. It's not, nothing's helping, nothing's changing, and I just think, yes, her division judge can deal with this when she goes before whoever that is. In the meantime, though,
Judge
I don't
Bober.
think there's any reason to have any confidence of her not engaging
Unemployed.
in drug
I have
use,
family ties.
substance abuse while out on the
I
street.
go to counseling.
Well, ma'am, I heard what you said, and it's not going to factor in my decision, but I mean, you're on probation for cocaine, you had prostitution last year, and you're out in the street,
That-
obviously high or drunk on something, and you're
I
out
don't-
dancing in the street. So it seems like you have not gotten past your substance abuse issues. So who is
The
who
judge,
is her judge? Do we know?
I can check that right now.
I believe it's Bober, Your Honor.
Ma'am, do you have to report to probation every month?
Yes, I do, sir. And I
they-
report.
Do they require you to submit to drug testing?
Yes, I do, sir.
It's only been 2 weeks.
That's true.
I mean,
Sir, I go to counseling also on Wednesdays.
it's not working.
Well, it's a process, Mr. Linder.
I understand, and Judge Bober can decide how the process should proceed. But right now, I don't have much confidence letting her out tonight that she's not going to be out in the middle of the road dancing under the influence of something.
Yeah, I think what I'm going to do is, ma'am,
Yes,
I'm
sir.
going to do this. I'm going to order that you are going to be. I'm going to release you on your own recognizance on both counts, but I'm going to order you to report to probation tomorrow between 8 and noon. You're going to have to drop a urine tomorrow, all right, ma'am?
Yes, sir.
Do you understand?
Yes, sir.
Okay, and then Judge Bober is going to find out whether you're really doing more drugs since you've been on probation. Now, do we know where she has to report to probation?
Well, that's the thing, Your Honor. And
I'm going to
that's
have her report to pretrial.
because probation's not going to know.
Go ahead.
Actually, Your Honor, if she doesn't report to probation, that will be a violation of a court
When is
order,
she,
and that would
when
be
is she
another
scheduled to
violation of
report? Do we know?
probation. Tomorrow.
Tomorrow?
You just told her to. You just
Yeah.
told her to.
Her
Between the first and the
her
fifth.
regular,
When's a regular?
My regular is between the first and...
That's fine.
My
Tell her.
my regular is...
Day after tomorrow. I mean, yeah, day after.
When is your report date?
My report is on the 1st.
On the 1st, Your Honor.
thank you.
Between the 1st and the
Yes,
what?
between the 1st and the 5th, sir.
1st and the 5th, Your Honor.
I'm going to ask her, I'm going to require her to report to pretrial release tomorrow between 8 and noon. She's going to drop urine tomorrow, ma'am. Ma'am, if you don't drop urine tomorrow, you can't complete the urine drop. Something's wrong. I'll consider that a violation of pretrial release, and I'll have you rearrested. So when you get up in the morning, you need to drink plenty of fluids, all right, ma'am?
Okay.
Now,
Thank you.
just to be clear, she's going to be supervised by pretrial and by probation.
Probably, and Judge Bober can take her off pretrial. So
Very good. Thank you,
release
Your Honor.
ROR.
Appreciate that.
Ma'am,
Okay.
Ma'am, tomorrow
picture.
between 8 and noon, you have to be at that address. Do you understand? Pretrial release. It's right across the street from where you are right now. Do you understand that?
Do you know the hours again, sir?
Between
Before
8
noon.
and noon. Between 8 and
Okay.
noon tomorrow.
Okay.
If you are not there by 12:01, that'll be a violation, and I'll have a warrant put out for your arrest. All right?
Okay.
If you,
There you go.
I don't want to give her. Do you live on 11th Street, ma'am?
Yes, I do, sir.
Okay.
In Hollandale.
Do you have that address? Hold on. Ma'am, do you have an apartment number?
Do you need more of those?
No.
Flex, it's a house.
Got it. There you go. Thank you, ma'am. Oh, ma'am, by the way, you have to be in front of Judge Bober. You may want to write that down. You have a court date in front of Judge Bober on November 20th at 9 a.m. November 20th, Judge Bober, 9 a.m. Thank you.
We got it. Thank you very much, Your Honor.
Sir,
It's Foster.
Letitia Foster?
He has a private attorney, Richard Bellis, Your Honor.
Hi, ma'am. Richard Bellis
Hi.
is your attorney, ma'am?
Yes, currently, I'm still speaking with him, but I did touch base with him yesterday.
Right. Okay.
He does, I'm sorry,
Go ahead.
Oh, no, I was gonna say, he doesn't know, my current situation at all.
Well, is he your attorney?
Yeah, but I'm saying I just had contacted him yesterday.
Okay.
Oh, got it.
Because I don't,
Got it.
yeah, I don't believe I'm eligible to get a public
I understand.
defender.
Hold on, ma'am. All right. Now, Miss Foster, what I'm going to do is count one will be 1,000. Are you working now, ma'am?
Yes, I currently start my new job tomorrow,
What type of work is
hopefully. I work in my community, the Seminole Res, as a librarian.
that? Do you, okay, so you're a Seminole, correct?
Yes, sir.
And you get do you get the monthly check from the?
Yes, sir.
How much do you? Is it? Okay. Bond's been posted. So, ma'am, you have the money to bond out, right?
Yeah, they gave me a paper with the bond. It says 3,500.
Right. That's correct, ma'am. Richard Bellis said ask you to call him when you get out of jail. All right, ma'am?
Okay.
Okay. Thank you.
So, all right. Thank you.
Thank you. All right. Crystal Walton, Carmela Mortimer, and Craig Freed.
Walton is a med reset, Your Honor.
Craig. North Broward, Maine.
All right. May I see Crystal Walton?
North Broward med reset.
Yeah.
Please try.
What?
Okay, I'll set Walton for. Is she on probation right now for anything? No, she's not. I'll bring her back Wednesday p.m. Got it. Okay, what about Carmela Mortimer?
Not
Yes.
bad, Your Honor.
Yes.
What do you do?
Possession of cocaine, drug paraphernalia. Miss Mortimer, are you currently employed, ma'am?
No, sir.
How long have you lived
Disabled.
in South Florida?
It's going on a year.
Do you have any money in the bank?
Not in the bank, no, sir.
Do you have money not in the bank?
I get SSI every month.
Okay. Do you have anyone who can help bond you from the jail, ma'am?
Yes, the phone number is in my phone in my property.
Okay.
It wouldn't be a problem to have me out of here today if that could access that.
Okay, defendant states she'd been, okay, needed help. Go ahead, state any priors?
1 moment, Your Honor, I'm pulling it right now. There you go.
You could also try the bonds people to contact whoever would bond you out, ma'am.
Thank you, but I know he has it and would be able to do it instantly.
Showing out of
Okay.
Pennsylvania in 2011, theft by deception. Multiple other thefts out of Pennsylvania with no disposition. Harassment by communications, 86. End of record, Judge.
Ma'am, based on the facts of the case, your criminal record, I'm going to say you're bonded at $1,000. Thank you, ma'am. How about
Thank
Craig,
you, sir.
Craig Freed? You're welcome. Craig Freed, Mr. Freed, you're charged with license suspended. Let me just look here, Mr. Freed.
Mr. Freed is present at the main, Your Honor.
I just had to stop here, but I didn't drive. The only reason I last night was to get the nitroglycerin. My father,
Mr.
he can
Freed.
breathe. Yes, Your Honor.
Mr. Freed, are you working right now?
I'm not, Your Honor. I'm taking care of my sister who has multiple sclerosis, legally blind, and my 80-year-old father had a heart attack.
Do you have any money in the bank?
No, I haven't worked because I'm the only caregiver for my family.
Okay, I'm going to set your bond at $100, so you can bond out. You have some failures to show up in court also on your driving record, all right? Thank you. How about Richard Jackson, Martiman Levy? Okay, Richard Jackson, loitering or prowling, sir.
Yes,
Richard,
sir.
Richard, you wanna resolve this case, this loitering today?
Yes, I do, sir.
How do you plead, sir?
I'm gonna plead guilty.
You understand we're not gonna have a trial, we're not gonna appoint an attorney, the case is over with right now?
Yes, I understand.
I'll withhold adjudication. Good luck. Take care, Richard.
Thank you, Your Honor.
Okay, withhold adjudication,
Yes, sir.
that's fine.
Martiman Levy?
Yes, sir.
Mr. Levy, same thing. You want to, loitering and prowling, you want to resolve it right now? Just plead no contest?
You want to resolve your case and plead no contest?
You don't have to.
Yes, he does.
Yeah, I mean, you could, if you want to, I'll release you on your own recognizance and you come back to court. What do you want to do?
I want to. Yeah, I want to come back.
Okay, I'll release you ROR. Thank you. Good luck.
Thank you, Your Honor.
All right, now, you know what? It's going to be a few minutes for Mr. Laundrie.
That's fine, Judge.
Yeah, all right. Okay, we're going to put Willie Miller off to the side. I got some, let me give you the ones I'm looking at here.
Yeah. This is
Here you go. Yep.
Here
Okay.
you go. I should have copies.
Now see, Sean Smith.
Okay.
Main jail.
Mr. Smith, you're charged with trafficking phenethylamines. I'm sorry, methamphetamine. Count 2, conspiracy to traffic in amphetamines. And court finds probable cause. I know we had, I believe, your co-defendant down here yesterday being
Yes, sir.
represented. Let me look here. I set his co-defendant at $40,000 yesterday on count 1. Go ahead, state. Excuse me. Do you have any? Court's going to find probable cause. I do see an address out of Newton, South Carolina. And,
North Carolina, sir.
Is that North Carolina?
Yes, sir.
Okay, sorry about that.
And depending on what the record may look like, we would like to request consideration for a bond reduction, Your Honor, please.
State.
Manufacturing cocaine base. Your Honor, it looks like he was just convicted. Pull up a little bit. A little bit.
Go ahead, State.
Convicted earlier this year in South Carolina for. Let's go down to the charge again. A little bit more. Manufacturing and distributing cocaine base, controlled substance. Nothing under 47 or CCI.
It's out of South Carolina.
Yes, Judge. That's on CCI. Just want to make sure. Okay.
Is that it?
Yes, Judge.
All right, so.
Your Honor, can I go sidebar? Can I go
sure.
sidebar?
So we're gonna, I'm gonna reset this for tomorrow afternoon. Thank you. Wednesday PM. Right. Put the bond back on him. The bond's been posted. Wait, what was the bond? No, just leave it ROR. That's a cash bond, he'll get the money back. Was it done through surety or done through cash? Just leave it ROR, he'll get the money back. All right? Okay. Now, Joseph St. Fleur.
Medical reset, Your Honor.
We did that yesterday with his attorney,
Oh, okay,
Tom Morse.
right. So that's just no bond, there you go. Okay, Alan McDonald.
He's here. He's on his way, Your Honor.
Understand?
President's Maine, Your Honor.
Good afternoon, Mr. McDonald.
Good afternoon.
Sir, you have the right to remain silent. You're not required or expected to make any comments or statements regarding your arrest or what led up to you being arrested. Whatever you say today will be used against you. Also, if you, everything today is being recorded. So the court strongly suggests that if you give up the right to remain silent, well, let me put it this way. I strongly suggest that you do not make any comments today about your arrest, but understand that you have the right to remain silent. You should utilize that right at all times. Everything's being recorded. Do you understand what I explained, Mr. McDonald?
Yes, I do.
Okay. Now, Mr. McDonald, you were charged with count 1, robbery with the firearm. Count 2, 3, 4, 5, 6 are burglary of a dwelling, structure, or conveyance armed. Count 7, burglary with a battery. Now, or burglary with an assault or a battery. So, State, do you, let me ask you this.
Your Honor, what I was hoping we could do is if we could go count by count, it might be easier that way than just.
Let me do this. Let me just see if I can clarify something.
Yes.
Is count 1 an attempted robbery?
Absolutely.
Okay, so count 1.
For the record, he, and this is the robbery or attempted robbery allegedly occurred at Ceviche by the Sea.
Right.
When he demanded the employee's car keys, and he did not obtain them.
Right. Okay, so are you seeking to foreclose bond and release conditions on count 1 today? Well,
No,
count 1,
it's not a PBL.
Count 1's bondable,
Yes,
right? Okay,
yes.
so we'll move on. Count 2 through count 6, are you seeking to?
And I was hoping we could go possibly count by count, Your
Okay.
Honor, because there's just so many different locations. For count 2, I would ask if we could treat count 2 as a ceviche by the sea.
Okay, so that's burglary of a structure.
And, Your Honor, I would argue that there is proof evident or presumption great that of an armed burglary. He entered the closed business. He had no lawful permission to enter into that business.
Right.
He,
Let me just get to that part of the, you got a lot of moving
yes, no, I know. It's,
parts here.
I'd be relying upon, the report that was written by,
I see right, okay. hold on. There's several police reports here, so,
yes, I'm gonna just find the report written by Officer Giles. It's page 2 of 6.
Officer Giles.
Well,
Okay,
the report.
I have Morales.
No, that's the. We'll get to that. That's the Oviedo residence.
I have Giles. Go ahead.
Okay, Your Honor. That he ran into the business through an open back door.
It's
headed for the
Ceviche
front
by
door.
the Sea is a restaurant, am I correct?
Yes, it is, Your Honor.
Do you know what time of day or night this would have occurred?
It
Late?
appears, Your Honor, if you go to the first page,
Right.
it lists this at. One moment, Your Honor. And I would mention that her occupation is the night supervisor.
Miss Veronica Oliva.
Yes, Your Honor.
Said, it looks here, she said that she was sitting inside of the restaurant waiting for the dishwasher to come back inside of the restaurant so she could lock the business. When an unknown male, later identified as Alan McDonald, this defendant ran into the business through an open back door and headed for the front door. He then started to run towards her. She stated she ran out the back door of the business, tried to get to her car, but McDonald chased her. Allegedly said, "Oh, so you're a runner." She stopped running, tried to reason with McDonald when he produced a knife and told her to give him her car keys. At that point, a witness pulled up who had seen the entire incident, got Miss Oliva into his vehicle, and then they drove away. They said they saw McDonald running southbound across East Oakland Park Boulevard, and it says here that there was a show up which was conducted. That means that the witnesses were brought to the alleged defendant, and that two of the driver of the vehicle who picked up Miss Oliva, they both positively identified Mr. McDonald is the one who attempted to rob her. And it says there was blood all over multiple doors of the business. They collected the blood for DNA. So.
And, Your Honor, first to answer your question, if the court would take judicial notice, I'm looking at Ceviche by the Sea's website. They closed on Saturday nights, and November 15th, when this allegedly occurred, was a Saturday. They closed at 11 o'clock at night. And I'm looking at the booking sheet. Mr. McDonald was arrested at approximately 12:44 in the morning. Okay. Actually, I guess this started Friday night and went in. So they closed still at 11 o'clock on Friday. So it happened at some point between 11 o'clock Friday and 12:44 in the morning on Saturday.
Okay.
Your Honor, I would just be relying, it would appear that there's proof evident or presumption great that when he entered the restaurant, and based on the other reports that Your Honor has been provided, he was armed with the knife. That when he chased her out of the restaurant, it was still in continuation of the crime he intended to commit of the burglary.
Do we know where he got the knife? Did he get the knife out of the kitchen, or did he get the knife?
It
did
appears
he have the knife with him?
It appears, Your Honor, that the knives were obtained from the first burglary. The actual first burglary that occurred, we haven't gotten there yet, but was at, just want to get the report.
Sunfish
Grill, Your Honor.
Okay. So there was an alleged burglary
Either that
at
or he was
Sunfish
armed.
Grill, then the burglary at Ceviche by the Sea, and I assume they're nearby?
Yes, Your Honor. Sunfish Grill is just down Oakland.
So let me
East.
just get the way this allegedly developed.
Or actually west.
Sunfish Grill, burglary, ceviche by the sea, burglary with attempted robbery, and then later on, he allegedly burglarizes 2 separate homes, correct?
Actually, 3 separate.
3 separate homes. Now, and they're all within that same,
It's
is
in
it
this-
A1A and Oakland Park
No, it's
Boulevard?
actually a little west. I believe it's the Bayview, the Coral Ridge area.
Okay.
Your Honor.
Now, let me ask, okay, so you're asking for proof evident presumption, great. We have 2 identifications, 2 people. There was a show-up positively identified him. Both people said he had a knife. Allegedly, he goes in the business, chases the woman out, and so it looks like armed burglary plus an attempted robbery, which is count 1. Now, let me ask the defense, do you have any issues with that?
No, Your Honor.
Okay, so the court on count 1 will find probable cause. Count 2, the probable cause on count 1 because it's an attempt. Count 2, proof evident presumption great.
Now,
On count 2,
Your Honor.
got it.
The burglary, I've reviewed the reports. I know you have. I know Mr. Atria has. The burglary for Sunfish Grill, at this point in time,
Right.
I would ask, at this point in time, that there's only PC. Whether I ask for more time or not, I may or may not.
Is that referring to count 3?
We can treat that as count 3, Judge. I'm
Okay,
fine
so
with that.
we'll say count 3 is a probable cause standard. I don't think that reaches, I agree with the state. It's not that strong.
I understand.
Okay, so count 3 is bondable. Okay, let's move on to count 4.
Count 4, Your Honor, I would treat that as Mr. Hunerberg's address at 2850 Northeast 30th Street. That's the first report.
That is by Officer Damanides.
Yes, Your Honor.
And I'm reading that, Northwest 30th Street, Bayview Drive, robbery. Mr. Hunerberg, at his residence in his apartment, advised that an unknown white male, later identified as Al McDonald, entered his residence through his unlocked front door and took a knife from his kitchen. He stated he did not know McDonald, did not invite him in the residence. McDonald, he asked him what he was doing. McDonald allegedly said, "Never mind, don't worry about it." McDonald continued into the kitchen, removing the knife from the countertop, tried to exit through the rear door, which was locked. McDonald could not exit through the rear door, so he ran out of the front door of the residence. There was blood on the interior of the front door handle and also on the interior of the back door. The knife in question was lying on the floor near the kitchen and also had blood on it. There was a show-up, and Mr. Hunerberg positively identified McDonald without hesitation. Blood samples were taken for DNA matches, and they allegedly found 5 knives were located on the floor of the patio leading to the front door. That's not Hunerberg. Sorry. Okay, that's a different one. Okay, so let's talk. Count 4 would be Hunerberg.
And Your Honor, there's also the next page has his show up witness ID form.
Up, that's the guy.
Your Honor, I would just argue Mr. Hunerberg witnessed him in his home. He witnessed him arm himself with a knife while he was in the home. I think there's clear intent that, at a minimum, he had intent to commit a crime of stealing or taking his knife, Your Honor. And Your Honor, I believe this is a straightforward proof evident or
It could be armed burglary, and the burglary is with an assault. So
I'm going to leave it as just the armed burglary at this point, Your Honor, because I think we'll get the. I believe the burglary with the battery and/or assault was intended for the next residence.
Okay, now, do you have any issue about count 4, proof evident presumption grade, Mr. Atria?
No, we do not, Your Honor.
Okay, so proof evident presumption grade on count 4. The court does believe that it's pretty straightforward on Mr. Hunerberg's residence. Okay, so now.
The next would be the, count 5 would be the Oviedo residence, and that's, it's actually mentioned in multiple reports. I know Officer Phillips goes into detail in her report.
Let me find that. Okay. Responded to an address on 30th Street in Fort Lauderdale. There was somebody there, Darvin Oviedo. He stated he was talking to his daughter's boyfriend, Mr. Brian Gomez, at the rear of the property when he got approached by an unknown white male. Oviedo stated that the unknown white male was holding a large knife and was walking towards him in an aggressive manner. Oviedo said that he and Gomez observed the male approaching with the knife and that both of them moved out of the way to avoid getting stabbed. As they moved out of the way from the rear door, the unknown male, later identified as Alan McDonald, made entry into Oviedo's property through the rear door that was open. Once inside, McDonald locked the door, leaving Oviedo and Gomez outside. Oviedo advised that his wife and daughters were inside. 3 daughters were inside sleeping in the living room area. The mother, his wife, stated she woke up when she heard, one of the daughters, take that back, Mary. She advised she woke up when she heard her father screaming outside and trying to make entry. The daughter told the police that she saw McDonald standing in the living room, looking around, holding a large knife. She said that she and her mother and sisters ran out the front door attempting to get help. She stated that McDonald exited the property right behind them and took off running down the street to an unknown location. So
now for the what I would also be relying upon for the assault and or battery aspect is Officer Fairburn's probable cause affidavit. If you look at the second page,
okay,
which says, and this is talking about the burglary at the Oviedo residence. The residence was still, however, occupied by a mother and her 3 daughters.
Right.
While inside, the defendant grabbed a 10-year-old girl by the shirt while armed with a knife, causing the girl to fear for her life. The homeowner had to break a window to gain entry into his house, causing the defendant to flee.
So that was Mr. Oviedo broke the window?
Yes. Yes,
because
Your Honor.
this defendant allegedly had the 10-year-old daughter by the shirt while holding the knife.
According to the information that Officer Fairburn had received.
Okay. Now, that would be count 5?
That would actually be count 5 and count 7.
Okay. Are you seeking to foreclose bond and release conditions on 5 and 7?
Yes, Your Honor, for the allegations that you stated on the record.
Okay. Now, Mr. Atria, do you have any issue with that?
No, Your Honor.
Okay, so proof evident presumption great is going to be found for count 5 and count 7.
Now, count 6, and that is the final residence. You know, I actually think there's very strong evidence. For today's purposes, though, I will stop short of proof evident presumption great. I just want to
talk about the alleged victim on that.
Well, the victim was not present at the home, Your Honor. That was a case where the Officer Fairburn was informed by the, let's see that report, was informed by the property manager.
Right.
This is, I just want to find the report. It might be in the first packet I had provided you, Judge. Yeah, I think it is. Yes, Your Honor. If you look at page 3 of 14.
Who's the officer on that?
This is Officer Phillips' report. It really, it's
which
women.
one? I'm trying to figure out which I'm looking.
It says 3 of 14 at the bottom.
I got it.
And it's starting where it says McDonald was detained behind 2900 Northeast 30th Street.
Okay.
And then it goes into that the officer was flagged down by David Cabeza, who is the building security guard.
Cabeza advised there was blood all over several potential entry points into the building, and he asked that I walk with him to ensure there was no damage. Cabeza pointed out blood on the door handle of an apartment. Cabeza advised the resident often leaves the door unlocked. He tried the door, found it to be open. Once the door was open, there was additional blood inside the door entry. Interior of the apartment. We called out but did not receive an answer. Walked inside. Okay. Condo was found to be unoccupied, but blood was found on the unlocked sliding glass door. The blood interior of the door handle. Okay. They couldn't make contact with the owner.
Ultimately, I'll let Your Honor make the determination. I think there's very strong evidence. Blood found at the points of entry and inside. Right. It makes mention, Your Honor, actually the next page, that he initially received superficial cuts to his arms from the burglary at the Sunfish Grill. And matter of fact, I believe one of the other burglaries, it was mentioned, and I think that was Mr. Hernenberg mentioned there was blood on the floor of his.
Let me ask you, arguendo.
Yes, Judge.
That last burglary, how do we know that Christine Russell, the alleged victim or the resident of that location, wasn't his girlfriend, and he was just going back there to find refuge? You know what I mean?
One moment, Your Honor.
I don't know that. I mean, it may not be true, but I'm saying that that's an equal
Right,
possibility.
exactly. There's no indication of any of that.
There was blood inside, no doubt about it, but there was no forced entry. And until Miss Russell steps forward and says that she doesn't know him and she didn't give permission, I'm not sure that I could find even probable cause for that burglary.
I understand.
Okay, so what I'm going to do is on count 6, I'm going to find no probable cause on count 6. No PC. No evidence of uninvited.
And Your Honor.
So here, let me go ahead.
Well, I was just going to say, in light of the fact that you found proof evident and presumption great on 4 of the 7 charges, I'm not going to be asking for time to perfect.
Okay. So on count 6, the defendant will be released on his own recognizance. Now, so that's count 6. Now, let's review. Count 1, attempted robbery with a firearm. Court finds probable cause. I need to set a bond for that. Count 2, the court finds proof evident, presumption great on count 2. The defendant will be held without bond. Count 3, probable cause is found. The court needs to set a bond on count 3. Count 4 and 5, proof evident, presumption great. The defendant will be held without bond until further order of the court. Count 7, proof evident, presumption great. The defendant will be held without bond until further order of the court. The court needs to set a bond on count 1 and count 1 and 3. State.
And if we
Go
could,
ahead.
before you go any further, on the counts that you just discussed, count 2, 4, 5, and 7, where the court found the presumption, proof evident and presumption great, and we would ask the court, pursuant to Preston, to set bonds on those counts.
The court notes the request from the defense. However, the court is of the opinion that once the state asked for foreclosed bond and release conditions pursuant to a first-degree felony punishable by life, as we have in front of us today, the court does not have jurisdiction, does not have authority or discretion to set a bond at first appearance where the state has made that request and the court finds proof evident, presumption great, and the court relies on not only the Preston case, but the Keel case, K-E-E-L, found recently from the 4th District Court of Appeal. So now let's talk about, does the defendant have any criminal record, State?
Yes, Your Honor.
Go ahead.
As far as Broward goes, his priors include trespass last year, loitering and prowling 2008, loitering and prowling, possession of marijuana and drug paraphernalia 07, DUI 02, DUI, drug paraphernalia, possession of marijuana 02. Your Honor, see prior arrests that I don't have dispositions for, so I'm not going to get into that. Additionally, can we go, Drew, is it okay if we go sidebar? There's some sense.
I'm going to go ahead and set his bond. The court's going to assume, well, if you want to add anything about his ability to make bond, I'm going to assume he has no money in the bank, he's got no assets, he can't make bond, but as a practical matter, he's being held on 1, 2, 3, 4 counts without bond, and the court will set his bond on count 1, the attempted robbery, which is basically an attempted carjacking on count one. The court's going to set that bond at $150,000 on count one. Count three is the burglary. That's the Sunfish Grill. I'm going to set that bond on count three at $25,000. And then that's based on your criminal record, the facts of the case, sir. I will order that you have no contact with any of the people mentioned thus far. Veronica Oliva, no contact with her directly or indirectly. No contact directly or indirectly with Darren Oviedo or any of his daughters or his wife. No contact to Mr. Hunerberg. No contact with Mr. Gomez. I think that was his name. Have I named everybody we need to name here? I believe I've done it. So, all right, sir. Mr. Alan McDonald, you'll be held without bond until further order of the court. Thank you.
Just make sure I did cover every base. I think I did, and I think we covered it. But count 2, 4, 5, and 7, you have denied the request for bond.
That is correct.
Correct.
Okay. There you go. Thank you. All right, here. Municipal ordinance cases. Could somebody hand them up to me?
Yes, Judge.
Got it. Okay, may I see Charles Thomas? May I see Charles Thomas?
Please.
You on the list?
Do you have Charles Thomas?
Apparently, he's not on any list, Your Honor.
No? What about... There's a reset from this morning, Charles Thomas.
They're going to check on it, Your Honor. Can we put that on recall?
Jacqueline Foster. Jacqueline Foster.
Another reset from this morning?
Yes. All reset.
That was one of the...
Not bad, Your Honor.
The female was there.
Okay, Jacqueline Thomas, possession of drug paraphernalia, ma'am. We have the City of Fort Lauderdale prosecutor in here. Good afternoon, sir.
How are you, Judge?
Your name?
Judge Don Laundere, City of Fort Lauderdale.
Okay.
Stephen Shane on behalf of the defendants, Judge.
Okay. Now, I don't know if she's already been appointed attorney. Ma'am, would you be interested in resolving your case today?
Yes, sir.
Okay. Let me ask, what is the offer? Drug paraphernalia?
Yeah, it was a catheist. Judge, she's only been in for a day. Yeah. Judge, I'm gonna need just to look at her priors real quick.
2012, she had possession of cocaine. 2011, possession of cocaine.
It's been more than 2 years.
Yeah.
Judge, we'd offer credit for time served on that one.
Okay, you know what I'm going to do, Mr. I'm not sure if we're going to appoint you on all three cases, but you've been in here quite a while, sir, waiting patiently, helping. So I'm going to appoint you on this case to pay you for your service, whether or not we're going to use you on each and every case, all right?
Judge, that's not how the city contract works. He has to actually be appointed to a case that he works on.
Well, he's worked, I mean, he's
No,
in.
I understand in equity what you're trying to do. That's just not how we work. Just for the record. We are trying to amend his contract to make it more equitable to him. We do appreciate him coming by. But we're not sure if his contract's even going to contain coming to magistrates in the future. We don't know.
Really? Interesting.
Well, that's because we can't find any federal case law, state case law, federal rules, or state rules that require an attorney to be present for a case that hasn't been filed and they haven't been appointed to yet.
Wow. All right. Okay, so here's what I'm going to do. Ma'am, would you like to resolve your case today?
Yes, yes, sir.
Ma'am, if you plead no contest, the case is over with today. Do you understand that?
Yes, sir.
Ma'am, do you have any money in the bank?
No.
Are you currently employed?
No.
Do you have any way you could hire your own attorney, any money to do that with?
No, sir.
Well, ma'am, I'm willing, if you plead no contest, then I'll accept that and you'll be on your way. You'll be out of jail by this evening. Do you need an attorney to talk to you about resolving the case today, or can you go without an attorney?
I can go without an attorney. I have resolved it today.
Okay, well, you know, if you need an attorney to talk to you, we can do that. You're okay without pleading no contest without an attorney, ma'am?
I plead no contest.
All right, ma'am. Do you understand we're not going to have a trial? Your case will be over with right now.
Yes.
I'll accept that. Thank you, ma'am. Withheld adjudication. All right, what about Charles Thomas? Do you have Charles Thomas?
They're going to get him, Your
Get
Honor.
him? How about Willie Miller? Do we have Willie Miller over there?
Not in the main, Your Honor.
Can somebody
John
get
Miller,
Willie
Your
Miller for me?
There you go, Your Honor. You gotta hang
Where is he?
No
Hey.
problem, Your Honor.
Hey, Mr. Miller, you're here for violating municipal ordinance. It said that you went over to the, I believe, the Hess gas station. You were spitting on the window of the gas station on West Broward. And defendant then smashed a business sign against the same window. All right. He said he was under the influence of alcohol when it happened. So, State, do you have any priors on this gentleman? Mr. Miller, do you have any money in the bank, sir?
No.
Are you currently employed?
No.
All right. Do you have a place to live when you get out of jail?
No.
Okay. Let me ask you, who's the president of the United States right now? Do you know?
Obama.
Okay. What do you get when you add 3 plus 2?
5.
Okay. Now, would you like to resolve your case today and get out of jail today?
Yeah.
Okay. Do you understand that I'm a judge? Do you understand that?
Yeah.
Do you know you're in jail right now?
Yeah.
Okay. Go ahead. Steve, does he have any priors?
From what I can see in Broward, he had a solicitation on a felony in 06. Alcohol. Oh, actually, that was declined.
Okay, so Mr. Laundrie.
Oh, yeah?
Yeah, the last
I mean,
one
he's got.
2008, but it was like a long time ago.
He might have some municipal ordinances.
No sex offender or anything like that?
Not that I can see.
Mr. Laundrie's been in jail now a couple days. How do you feel about this?
Judge, what he did was pretty bad, but if he doesn't have anything in the last year, I'm going to offer him credit for time served. I'm going to ask the court to just order restitution reserved to as amount, seeing as there might be some damages. I don't think there's going to be a way to get the restitution out of him, but I think
Probably
in just,
correct.
just as a rule, that's what we will do, and we will take 60 days to set the restitution hearing if we feel necessary.
Okay, Mr. Miller, would you like to resolve your case today and plead no contest?
Yeah.
Now, do you need me to have an attorney go over this with you, to talk to you about this, to discuss this matter with you, or can you go without an attorney?
Yeah. Both.
What is it, sir?
Yes.
I don't know what he's, yes to what?
Do you want an attorney?
Mm.
He doesn't want to. He does not want an attorney, Your Honor.
Okay, Mr. Miller, do you understand that you have a right to have an attorney? And I'm going to give you a free attorney to go over this with you if you'd like one. But if you don't want an attorney, I'm not going to make you have an attorney. If you don't want an attorney, you can say, Judge, I don't need an attorney. Which one would you like? You want an attorney or no attorney?
He does not need an attorney. That's what he said, Your
Are
Honor.
we sure that's what he said?
I'm sure.
Okay. You satisfied that he said that, everyone?
Judge, I am.
I mean, it seemed like that's what he said. All right. Does anybody think that this needs to go to Judge Lorna Wren?
They just won't listen to you guys.
You know? Sir, do you plead guilty or no contest to this charge?
Both.
Well, pick one of them. Guilty or no contest?
No contest.
All right.
I guess
I'm going to accept that. I'm going to withhold adjudication. Thank you.
is it just me, and I know you guys too, but is there just something fundamentally wrong?
Sorry, Mr. Shade.
Oh, that's okay.
Okay, what about...
Your Honor, can we come back over to Main?
Amount to be determined within 60 days.
Thank you, Judge.
All right, do we have Charles Thomas there?
We do, Your Honor, and just to kind of speed things along, they've heard what you said to all of these other defendants. Everybody standing behind me wants to resolve their case. None of them want to have an attorney appointed, and none of them want to hear that again.
Well,
Hello.
you know...
Oh, no, you didn't.
That's how it works. Is he there?
No, you didn't.
All right.
Tell that man that shit.
May I see Charles Thomas? Is he over there?
Come on, Mr. Thomas.
Thomas,
Hey, I didn't say it.
Thomas,
Yes, sir.
drinking alcohol in public. Would you like to resolve your case today?
Yes, sir.
All right, sir, do you have any money in the bank?
No, sir.
Do you have a job?
Currently not. I don't have that
Do you have any way to hire an attorney if you needed one?
No, sir.
Well, let me ask you this. I have a very fine attorney over here named Mr. Stephen Shade, who's an expert in open beer can cases. Would you like me to appoint him to represent you? Do you need to talk to him about this case, or can you go
No,
without
sir.
an attorney?
I go without an attorney.
Do you understand that by pleading no contest today, your case is over with today? You're not going to have an attorney. Case is over with. You'll be out of jail here sometime this evening. Do you understand that?
Yes, sir.
Okay. I'll accept that. I'll withhold adjudication. Well, thank you.
Thank you.
Have a seat outside.
It's interesting how when you tell people they'll get out of jail today, they don't need an attorney.
About 6 years.
Interesting.
I'll get around by depots. It's starting at 2:30. If you need me, I'll be up right upstairs. Just
Yep.
text me and come back down.
All right.
I'll be,
Well,
I'll be here too, Judge.
okay.
Thank
Sure.
you.
You're in one, right? Grade 3?
Yeah. I think they're in the other room with Marge.
Just want to make sure they stay.
Okay. Now. This is popping out. Give me a moment here. Where is Andrew Sterling or Joseph Sterling? Joseph Sterling.
He's not on the list. He's a receptionist.
I'm just gonna release him on his own recognizance.
No problem.
Is he there?
Yeah, Joseph Sterling, let's go. Huh? Oh, God. Yes, Your Honor, he's here.
Well, I don't know what I'm just saying. No, just give them to the clerk because they have to link it. You know those things you get.
Come on.
You know those things you get from the 4TCA?
Right.
No. If they file
Come.
this one, the 4TCA has to know what the judge took into consideration. He needs all the people. They need all the people that the judge has. Yeah, but I'll explain to you at the beginning.
And I'm back.
It's so confusing.
Hi, Mr. Sterling.
Sterling.
Hi, Mr. Sterling.
Hello.
Sir, you're here for alcoholic consumption in public. I'm going to release you on your own recognizance. Thank you, sir.
Okay.
I see Daniel Sherman. Daniel
President of the Maine, Your Honor.
Sir, count one.
Yes, Your Honor.
Count one is cannabis. Count 2, 3, 4 are open alcohol violations. And count 5 is the same thing. I think count 2, 3, and 4 actually were, oh, those were Oakland Park. That's right. Okay, sir, I'm going to do this. I'm going to release your ROR on 2, 3, and 4, and 5, and you're going to have to bond out on count 1 for $100. Good luck, sir. Thank you.
I don't have $100, sir. Can I possibly just resolve it?
No, we're not going to resolve it today.
Because it was just a very little bit, that's all.
Right, and
It
you don't
wasn't
show
too
up
much
in
at all.
court as evidence on count 2, 3, 4, and 5. Your bond's $100. Thank you. Good luck.
Okay.
Good luck.
How about Philippe Walker? Philippe Walker.
No fraud, Your Honor.
Mr. Walker, possession of methamphetamine and possession of controlled substance. All right. All right, Steve, do you have any priors on this gentleman?
Checking right now. Philippe Walker.
Okay.
Did I get another paperclip? I'm sorry. Oh, wait a minute.
Hi, Mark.
Did you go get that one?
Oh, yes, thank you very much.
Go ahead. Steve, do you have any
I just need
priors?
to check the status of a case, Judge, and I'll get right with you.
Okay.
I'm lactose. Actually, Judge, he has a pending theft that's in Judge Lerner Wren's other division right now.
Okay. So I'm going to set your bond at 1,000 on count 1, 1,000 on count 2. You can bond out. You have an open case right now. Thank you.
Yeah.
No, don't worry. Just ignore Eric.
Are you laughing?
Okay, may I see you?
By using the term other division. Okay. That's messed up.
I see Angela Brown.
I know.
Hello.
But that doesn't.
Okay, now, where's Angela Brown? Do we have Angela?
That's a Paul Ryan medical reset, Your Honor.
Okay. I'm not even going to do that. I'm just going to release her ROR on all. I straightened that out. MO10, right? I got that. Release her ROR. Now, yeah, both counts. Let me see. Mangiel, line them up, Mr. Line them up.
We still have Zabala.
I'm sorry, Arthur Waller, Your Honor. He's here on a second look. Space just back up a little bit. You're good. You can sit. We'll get you when we're done.
He already went.
You don't want to hear the story either. You don't want to hear all that crap.
Explaining one of them was in the hospital and one of them I couldn't be.
Arthur Wallen. Hold on, Mr. Wallen. Just give me a quick moment. I'll be right with you. Try to get everybody out of here really quick. Just give me a quick moment. Okay, Mr. Wallen. All right. Yeah, I remember this. Just give me a quick moment. The City of Fort Lauderdale prosecutor was here. Yeah, Shade, they're both here. Observed sleeping out in the open, private property. There are no trespassing signs. 540, okay. I don't even know where this was. But look, you got two cases. We had the prosecutor here, defense attorney here. Would you like to plead no contest on both of these? You're done. You're out of here. Do you understand that, Mr. Wallen? Turn on the mic. I can't hear him. Thank you.
Yes, sir. Yes, sir. Yes, sir.
I said, yes, sir.
Sir, Mr. Wallen, do you need me to appoint an attorney to help you make this decision? Can you go without an attorney?
I can go without a turn,
All right,
sir.
I'm not pressuring you or forcing you to do this without an attorney, am I?
No, sir.
Okay, how do you plead to these two charges of trespassing?
No contest,
Okay, I'm
sir.
going to withhold adjudication, sir. Good luck. Thank you. On both
Is that
counts.
it?
On both cases. Yep, you're done. Thanks.
All right. You're done. Thank you very much. Go that way, please. Roger Clark. Martinez, Angel. Angel Martinez, Your Honor, second look.
Okay, Mr. Martinez.
There's a couple.
Okay, Angel Martinez, leaving the scene of an accident on suspended driver's license, careless driving. Martinez, how come you haven't bonded out of jail yet?
Because I don't have the money to bond out right now, sir. I'm not working at the current moment.
No? How long
No,
have you
sir.
lived how long have you lived in South Florida, sir?
All my life.
I'm going to release you on your own recognizance. Good luck, Martinez.
Thank you, Your Honor.
Yes, sir. How about,
Thank you, Your Honor.
Who's next?
Who's next?
O'Neill Denal.
Yeah.
O'Neill Denal.
No,
Dinnal,
you only
Your
had
Honor.
one. What's his name?
O'Neill Denal. Dinnal.
Okay, I got it right here. Sir, possession of cannabis. I'm going to release you on your own recognizance. Good luck. Thanks.
Thank you, Your Honor. That way.
Who's next?
David Archer.
David Archer,
Hey,
Your
good
Honor.
to see you again,
Second
Mr.
look.
Archer.
How you do?
Open container of alcohol, Archer. I think this is Pompano, isn't it? No,
Yeah.
Oakland Park. Oakland Park.
Oakland Park.
Okay. Look, here's the thing. I don't have an attorney here. I don't have anyone here. I can do one of two things. I can release you on your own recognizance. You get out of jail tonight, and that's it. However, the case will still be active, and you could get a warrant because you won't come back to court. I think realistically you wouldn't be able to get notice. However, if you want to plead no contest, we'll end it right now. You never have to deal with it again. What would you like to do?
Plead no contest.
Okay, now, I don't have an attorney here. Do you want me to reset this case for maybe tomorrow to get an attorney here? Or are you okay without an attorney?
I'm okay without an
Do
attorney.
you think you're being pressured or forced to make this decision even though we don't have an attorney in this courtroom right now?
No, sir.
I'm interested in getting you out of the jail. You understand that?
Yes, sir.
So I don't want to keep you in jail overnight because I want you to get out of the jail and enjoy yourself. So do you
Right,
plead
sir.
no contest to this knowing that there's no attorney here?
I plead no contest.
Okay, I mean, this is an open container of alcohol, not exactly a complicated matter. Okay, I'll accept that, sir. I'm going to withhold adjudication. Good luck, all right?
Thank you, sir.
Yes, sir. Okay.
Thank you, Your Honor. Robert Titus, second look.
Okay, Mr. Titus, discarding litter. I'm trying to figure out what was the litter. Seems like I remember this, but it slipped me. Titus. I don't even remember what the litter was. All right, City Hollywood was here earlier. Throw a plastic
Wait, he
bottle.
was on yesterday.
Throw an empty lemonade bottle on the east side of the sidewalk. Defendant discarded litter upon. Okay, so would you like to plead no contest? Case is over with right now.
Yes, sir.
Well,
no contest, sir.
All right, sir. We had an attorney in here before, Mr. Shape, but he had to leave. Do you need an attorney back here? I can call him back to help you make this decision, or can you go without an attorney?
No, I can go without an attorney.
Do you think that going it without an attorney is violating your rights, or you're being pressured into making this decision, or can you go without the attorney and just plead no contest?
I can go without the attorney and plead no contest.
Okay, I'm going to accept that, sir. I'll withhold adjudication. Good luck. Thank you.
First of all,
All right, thank you, sir.
you guys aren't
David Archer. Top of the
Roger Clark, Your Honor.
Robert
Second
Clark.
look.
Okay.
Roger Clark.
Thank you.
Roger Clark.
Roger, right?
Roger Clark.
The usual spelling of the bar.
Is that a felony?
Yeah,
Roger Clark?
I don't have that docket.
I don't even see it on the docket.
you can say it 18 times.
Another name, perhaps?
Sir, are you known by any other name?
No.
How many games?
I don't know. I don't have
It's
him
not a
on
great
here.
start, but again,
Sorry.
in that case.
He's on the BSO list.
I don't have him
Yeah,
on
but
my
he's not on the
docket, so
docket,
we're going to
so-
have to reset you, sir. Thank you. Next
Okay.
person, please
Sorry,
come on
dude.
up.
And that's Bernard, what's your last name? Martin. Bernard Martin, Your Honor.
Bernard Martin, page 3. Mr. Martin, open container of alcohol, sir. Now, that's Hollywood also. The Hollywood prosecutor was here, defense lawyer. Sir, the offer to resolve the case is a withheld adjudication, get out of jail tonight if you plead no contest. Is that what you want to do?
No contest.
Now, sir, this is for having an open can of beer. Do you want me to appoint an attorney to represent you on this, to go over the case with you? He was here, and I can call him back. Or you can just say, Judge, I don't need an attorney. I just want to plead no contest and get out of jail. What would you like to do? Do you want me to call the attorney to come advise you of your rights and everything about the case? You just say, Judge, I don't need an attorney.
And then
I don't need an attorney. That case was 9 months ago.
Okay.
I haven't drank since.
Do you want to just plead no contest and get out of jail
No,
right
no
now?
contest.
Okay.
Goodbye.
So you don't need the attorney. You just want to plead no contest and get out of jail, right?
No. He's been
Exactly.
Okay. I'll accept that. I'll withhold adjudication. Good luck, Mr. Martin. Take care of yourself.
Thank you.
Yes, sir.
Our final one, Your Honor, is Stalling Zavala, and he is on page 6 of your docket. This is the proof evident presumption great carried over from this
I
morning.
understand.
Mr. Atria is going to be making the major argument in this case.
Mr. Stalling Zabala, you have the right to remain silent. If you give up that right today, whatever you say today can and will be used against you. You're not required or expected to make any comments about your case. But if you give up the right to remain silent, whatever you say today can and will be used against you. The court strongly urges you not to say anything about what led up to you being arrested, the facts surrounding your arrest, any of that. I strongly suggest you don't say a word. But if you give up the right to remain silent, everything's being recorded, and what you say will be used against you. Do you understand what I've explained, Mr. Zabala?
Yes, sir.
Okay. Now, you've been charged with
Turn off the mic now.
first-degree premeditated murder. You're alleged to be a principal, also known, I guess you could say, as an accomplice, a co-conspirator to the crime. Now,
Well, I just want to say, and I think just for record purposes, principle is the key word, Your Honor.
Right.
Because, and I've given this consideration. I actually looked into it. I know based on what he said that he may want to argue that he withdrew, but that's only a defense if you are a co-conspirator or an attempt. It is not under the statute.
Right.
It is not a defense to a principal. So.
right. I agree.
I just want to make a record. I know you know that.
Those are the finer points of law, but I was just trying to put them in common parlance that
I understand.
he allegedly assisted. He didn't actually commit the ultimate crime. But as a principal, if you assist, you help, you do anything in furtherance of the crime, you're a principal. Okay. So, now, first-degree murder allegedly of one Eber Dagberto Lucero. He also had an alias, I believe, as Santos Hernandez, but his real name was Lucero. And we found proof evident presumption great today based on these facts regarding the defendant's co-defendant in this case we had earlier. Now, State, are you seeking to foreclose bond and release conditions today?
Yes, Your Honor.
Okay. Could you just briefly make a proffer on why you believe this defendant should be held without bond?
Well, Your Honor, if it's okay with the court, can I rely upon the underlying allegations that I brought up to the court on Mr. Lamus's case rather than go over the specific allegations with regards to Mr. Zabala that I would argue satisfy proof evident presumption great. Most notably, the most important allegation is that it was Mr. Zabala that broke into the victim's home by his own admission, and I believe he used a knife or a knife-like object to actually break and breach the door to allow the other two co-defendants, or Mr. Pierre and Mr. Lemus, into the home. According to reports, he then entered the home with them, and Your Honor, I believe also, and I want to find this in the report because I think it's important. It says, Your Honor, on page 4, that Marlon Gonzalez stated that Zabala stated that Lemus and Pierre began searching the victim's house for something. Marlon Gonzalez stated Zabala told him that he observed Pierre and Lemus beat and stab the victim, and that Pierre had a knife and Lemus had a machete. Additionally, one moment, Your Honor. Okay. This is from page 5. Zabala stated that he knew and saw Pierre in possession of a folding box cutter knife at the victim's home. Why I believe that is relevant, and I think that is part of what satisfies proof evident presumption grade, is that knowing that Mr. Pierre entered into the victim's home with both Mr. Zabala and Mr. Lemus, and he was armed at the time with the box cutter type knife, it is a foreseeable conclusion or foreseeable consequence that based on the revenge that was going to take place against the alleged victim, that his death was a foreseeable consequence.
Okay. Okay, and then ultimately, the alleged victim was killed.
Yes, Your Honor.
Stabbed multiple times, I believe.
The coroner's report, medical examiner's report stated cause of death from multiple, I don't know exactly how many, but more than one stab wound.
Okay. Now, is there any comment from the defense?
Yes, Your Honor.
Go ahead.
Judge, our argument regarding this situation is that the independent act of Mr. Pierre has nothing to do with Mr. Zabala's participation. He entered, by his own statement, just intending to batter the victim, because, he was struck with the victim's car. He didn't intend, as the independent jury instruction 3.6 sub 1 requires, that he didn't intend this to occur, and he didn't participate in it, as section 2 of that independent act jury instruction informs us, and as section 3 goes on to say that this was not a reasonable, as the state has said, a reasonable foreseeable consequence of the common design contemplated by the defendant. The defendant intended just to beat him up. The jury instruction says that if you find that the defendant was not present when the crime, the murder was occurred, it doesn't establish that it was an independent act of another. However, the jury instruction goes on to indicate that if you do find that the crime, the murder, was an independent act of another, which it was, Mr. Pierre, then you should find Mr. Zabala not guilty of the murder. So we're alleging that this was an independent act, not intended to occur on Mr. Zabala's part. His conscious intent in the principal aspect of this was that just batter the man, and then he leaves. As a matter of fact, we know that from this morning's argument, Mr. Zabala does leave because he sees he hears a snoring from a room, opens it up, sees a baby's crib, and on page, let me see what I can tell, page 5 of the affidavit, he 1, 2, 3, 4, 5, the 6th paragraph, a little bit, almost halfway down on the right-hand side, he decided not to follow through with the beating, which is what he intended, and he left. So, what happens after he leaves is beyond his knowledge, beyond his intent, and beyond his participation. So he didn't intend it, he didn't participate in it, he has no idea what's going to happen when he leaves, his better choice is that he decides he's leaving. He's decided he does no longer want a part of this. So our position is that based on the jury instructions, Independent Act 3.6 sub 1 and principles, you should find not proof evident nor presumption great for Mr. Zabala. And I don't know if Mr. Miller has any other particular aspects that he wants to add along with this. The state had also acknowledged or cited this morning a unreleased, not released Hunter case, which was cited at Hunter v. State. Let me see if I can get this. 214 WL 514-9153. It's not been released and it's subject to revision or withdrawal. However, in that case, the appellant Hunter had said that she wanted the victim, quote unquote, murked, which in the body of the case law is a slang term for murdered. There's nothing that would suggest Mr. Zabala wanted anyone murdered. He just wanted the man roughed up.
Your Honor, if I may briefly, Drew, do you have a copy of Hunter? Because actually, Your Honor, if the court would read Hunter, because actually what the court in Hunter says is some witnesses said the defendant wanted him murked. What the court actually says is, even if that's not the case, if the judge could take it, even if that's not the case, the court is very clear on this. Intent is not what matters. Because in that case, what she was claiming was that our intent, it's actually very similar to this case, which to commit an act of revenge, a battery and an act of revenge, and she had no idea that this person was going to be killed. Matter of fact, it was an accident.
Can I just interrupt?
Yes.
Isn't this basic law school 101? I always use the bank as an example to make a point. But if 3 people go into a bank with masks on, they go into the bank, maybe one has a gun, the other 2 are unarmed. But the other 2 are going to be lookouts, they're going to go in the bank, they're going to help the guy with the gun rob the bank. Now, they know the guy has the gun, they know the gun's loaded, but they don't think he's going to shoot anyone. He's just going to scare people. But it turns out, during the course of the robbery, he shoots the bank guard. Now, the other 2 people can't get out of their culpability by saying, gee, we had no idea he was going to shoot the bank guard. We just thought he was going to scare him. But, I mean, in this case...
Can I jump in here?
But in this case, this man, while people are sleeping and there's a baby in the crib, they're going in for revenge. This gentleman allegedly pries the door open to get inside. He knows that another man he's with has a box cutter. Now, the box cutter's not used to just rough someone up. We know a box cutter, that's used to slice someone, and the other man's got a machete. So, is it reasonable to believe that picking the front door and getting in there at night when people are in bed, when you
Just
see
hold on.
2 of your friends, your co-defendants armed like that, that there's probably going to be someone severely hurt? Are you less culpable if you say, gee, I didn't know they were going to kill him, I just thought they were going to rough him up? I mean...
And the reason, Your Honor, it's relevant is if you read the Tucker case, that's exactly what the defense's argument was. Because what happened was the victim was being struck in the head with a gun, pistol whipped, and the gun went off and killed him. And what the 4th DCA said was, it is up for the jury, and that is a foreseeable consequence. Certainly, when it's the motive is known revenge, like in the Tucker case, where you're breaking into someone's home and you see one of the people with a box cutter and the man's sleeping, it certainly be argued it's a foreseeable consequence that the revenge that is going to be committed could result in that man's death.
My turn.
Go ahead.
Thank you, Your Honor. Thanks for allowing me to pitch in here. Okay, first of all, Hunter is distinguishable from our facts here today. In that case, no one left when the guy was being pistol whipped. No one said, we're not into this, we're taking off. Okay, they were there the entire time that the guy was getting pistol whipped. So it's reasonable that they could be charged under the principal theory, and that's all that Hunter is about, is whether or not the state can properly charge the principal theory under these facts. So what's distinguishable here, I think, is that... Yes, sir.
Let me ask you a hypothetical.
Yes, sir.
Say that 3 people break into somebody's home while they're sleeping. There's no
Yes,
weapons,
sir.
there's no gun, there's no nothing. They burglarize a home while a man is sleeping. One of the people gets into the bedroom and punches the man in the face when the man objects to them being in the home. That's a burglary with a battery. Is it your position that the other 2 people in the home would not be guilty or not culpable as principals because they're not the ones who punched the man in the bedroom?
Okay, again, under that fact pattern, all three of your co-defendants are participating in the burglary.
Right.
Under our situation, okay, two of the co-defendants abandoned. They said, forget this, we're out of here. Okay, there's a baby, we're not having any of this. And they left. Okay, now keep this in mind. The man whose idea this was, allegedly, the person who wanted the revenge, okay, abandoned the revenge and left. It's reasonable for him that everyone who's supporting him is going to leave with him. In this case, it didn't happen. But his reasonable expectation is, I quit, you quit with me. This didn't happen, apparently. I think we have a strong argument for an independent act, and as long as we have an argument, you do not have proof evident presumption great. As long as we have a defense to bring to the table, there is no proof evident presumption great. It is a trial matter. It's a matter for the jury to decide. You do not have that high standard. There is now a reasonable doubt.
I believe, with all due respect, you are mixing two matters. Proof is one thing. Whether or not you have a defense is another. So, and I'm not sure that...
This is why I brought up this. It seems what Mr. Miller's referring to is withdrawal. That is not a defense. Abandonment withdrawal is not a defense on a principal theory. Secondly,
only under
a conspiracy or attempt. Secondly,
but independent act is and was actually argued in the Hunter case.
We're kind of going back.
All these acts were in furtherance.
What I'm saying
Mr.
is,
Miller, I'm going to give
as
you the
long as
last
there's
word.
a
I'm
defense,
going to give you the last word.
Well, I appreciate that.
Go ahead, last word.
As long as there is a defense, there is reasonable doubt. If there is reasonable doubt, there cannot be proof evident presumption great. I'm urging the court not to find proof evident presumption great in this case and to give my client a reasonable bond.
Okay, sir, the court disagrees. The court's going to find proof evident presumption great. This defendant allegedly jimmied the lock or pried open the door late in the evening or early in the morning hours where he knew somebody was asleep in bed. He allegedly knew that the people he was with were armed and they were seeking revenge, and he helped get in the house with them. He went in. It's reasonable. The court believes that he knew what was going to happen, that the man, great harm was going to come to the man in the house, and the court believes that he acted as a principal. The court relies on the affidavit attached here too. He made admissions, and based on that and based on the admissions of one of his co-defendants and the court noting the death of the alleged victim by the same means that this defendant had witnessed, the knife, the box cutter, the machete, the court will find proof evident presumption great. Sir, you're going to be held without bond until further order of the court. Go ahead, defense.
Yes, Judge. Yes, we would ask the court not to hold this gentleman on a no bond hold. We would ask you to exercise your discretion and set a bond.
Pursuant to the Preston case and the Keel case, K-E-E-L, out of the 4th District Court of Appeal, the court believes that this court lacks the authority and lacks discretion. Go ahead. To give a bond or release conditions once the state has requested bond and release conditions be foreclosed and finding a proof evident presumption great. The defendant's only matter of relief is to have a full-blown Arthur hearing before his trial judge. Thank you.
Thank you, Your Honor. And thank you for the accommodation.
No problem. No problem.
Good job.
Why is this in my hand? What am I doing with this?
Now, you have to take the abuse from the clerk.
Yours? Here you go.
Order that in case it's not on the document.
Okay, now, do you have something on the docket, Mr. Romero?
No, I do not, but
Yes
speaking
and no.
with Mr. Lender, it was an error on my part. I thought it was, but it was my fault. I didn't fax it
Got
in.
it.
But Mr. Lender has agreed with me. We looked at the days on DeBar's signatory. I'm preparing a short order on case number 14013200 CFNA to have him have an ROR, Your Honor.
Got it. Okay. People at Paul Ryan facility met the two women in the front. Why doesn't somebody just step forward? And then, ma'am, you'll be next. And then, sir, in the back, you'll be after that. Come on up, ma'am. Tell us your name.
Speaking of which,
turn on that mic right there. You have to hit the button over there. Can't hear you.
See, this is what happens.
Still can't hear you.
There you go.
Tanisha Garner.
She keeps touching it.
You have to.
Tanisha got.
You have to press it down, I think.
I just leave it alone. She keeps.
It's not the first time it's happening.
You can hear me.
He's not.
We're gonna get this right eventually.
Well, maybe.
Now.
Could I? I can hear you now.
Hey, Tanisha got.
Okay. She keeps touching it.
Busy. You called. I'm sorry. You called upstairs.
Right. This is defendant didn't show up in court. So, no driver's license. Ma'am, how come you haven't bonded out of jail yet?
Because I don't have no money to bond out.
Okay, I'm going to release you on your own recognizance. I'm going to give you another chance to show up in court, all right?
Yes.
Tanisha
But
Gardner?
I have another
Are they all
charge
driving?
that's holding me. No, petty theft. I have a petty theft.
Well, I'm going to release you on your own recognizance on this no driver's license, all right? Thank you.
Okay.
All right, now, who's next? What's your name, ma'am?
Brittany Miller.
Okay, Miss Miller. Ma'am, it's a prostitution charge. How come you haven't bonded out of jail yet, ma'am?
I have no money.
Okay. Did you have any type of employment, legal employment, before you were arrested?
No, sir.
Do you have family down here?
No, sir.
Where's your family?
Alabama.
Do they know you're in jail?
No, sir. I do not speak to them.
You don't speak to your family? Do you have children, ma'am?
I do not, sir.
You already posted one of that.
Look here.
Why do I know more about your clients than you?
Okay.
Okay, why do you? I'm shocked. Mm-hmm. He deceived you. Get out of here. Get out. Yeah. It's something stepped up. Yeah, yeah. So give it to the clerk. Get the clerk. If it.
Yeah, you had a prostitution already once this year. This is your second prostitution this year. Ma'am, I'm going to let you go see your judge. Thank you.
Who's this?
What's today's date? Oh, gee. 14. Okay, what's the?
Do you know if anyone ever figured out who worked with these detectives in this case?
There you go.
I was curious. All right, well, if it is.
Okay. Now, what's your name, sir?
Whoever it is you live with.
Boris Johnson.
Mr. Johnson. Okay, just give me a moment, sir.
It's a second look, Your Honor. It's felony.
Mr. You're Tavoris Johnson?
Yes.
Okay. Second look. How come you haven't bonded out of jail, sir?
Because you raised my bond. It was originally $600, but you raised it.
I raised your bond.
Yeah.
Are you sure I raised it?
I'm positive, Your Honor.
Well,
I was in the main jail on Thursday.
does he have priors? I mean, I don't usually raise bond. I'm usually not a bond raiser.
I have the paper right here.
Well, let me find this real quick. Let me see if I can get you. Yeah, that's probably what he's talking. Right. Yeah, I don't think I raised your bond, did I? I don't think I raised it. It's 5,950. It's about $6,000. $5,950. I didn't raise your bond. I left it the way it was. So, are you going to bond out? Right? And I have a resisting arrest and grand theft. He's got 2 prior bills, 2
The driving with habitual, I have to pay the $45 for the reinstatement fee.
Let me ask you this. I mean, if I lowered your bond a little bit, could you bond out?
Right. When?
I can't hear you.
I just want you to stay here.
No, push the button, sir.
Push the button. We got a real button issue over there.
Yes.
By the time you get there and have to leave, it's...
So let me look here.
You'll be home in about 20 minutes.
Okay, bond.
Whatever.
Let me look here.
I'm going to leave them in your desk.
Count 1, I'm going to reduce that bond.
I'll put them in your desk.
To 1,000. Count 2. Heroin, I'm going to reduce that bond to 1,000. Count 3. Count 3, 4. Count 3, 4, and 5 are ROR. Yep. Total bonds, 2,000.
Thank you, Judge.
Yep. So ROR. So your total bond today is $2,000. All right, sir?
Okay, thank you.
You're welcome.
Hi, this is how lady?
No.
Okay. All right. Thank you.
I started to deliver, but I ain't got to have one of that. You throw that shit in my car. No. You get a nigga around home. I'm letting niggas know what time it is. He not, yes, he is.
Okay.
Look, drop the shit down. Get out in.
Okay, now, I think we're done there. Let's go. Conti, who do you have over there? Mr. Fahey?
Yes.
I'm going to send this to your trial judge, sir.
Your Honor?
Yes, sir.
Is there any way? My mom is losing her house. There's no way she can bond me out. Is there any way? I have a job. Is there any way you can release me on pretrial or probation or RR?
No, sir. I'm going to send you to your trial judge. Thank you.
All right.
Okay. Anybody else at Conti? What's your name, sir?
Carl Jones.
Okay. Hold on one moment. What is your name? Say your name again, sir.
Kyron Jones.
Kyron Jones. Okay, give me a moment.
Look what he did to me. Stepped on my shit. Took me to the train track and stepped on my shit. You fucking hero of this shit. Hey, with that bullshit. Yeah. Lee. Travis Lee. Man, you did not know that? It was his fault that said, yeah.
Jones,
This
is a weapon. Okay, just give me a quick moment. I want to look at something here.
And I came home for you. And he's gonna mess him up and get caught with this woman. Right. They say school.
So I'm going to release you on your own recognizance, Mr. Jones. Thank you.
Your Honor.
Yes, sir.
Yeah, I just had a question to ask. Is it resolved or is it?
No, you'll have to come back
Gotta
to
come
court,
back.
all right?
He's just releasing you without a bond.
Marcus Knoll.
Marcus Knowles. Marcus Knoll. Got it. Marcus Knoll, petty theft, sir. How come you haven't bonded out of jail?
Because I don't have anybody to bond me out.
Who? Yeah, we did good yesterday. Huh? I'm glad they got our prize. No, you know why? Because I was taking your property, I was taking my mix, taking pictures. I took the pictures. So it's my first dope charge.
I ain't got no problems now with no license. This is my first piece too. And then I got a pay for them that I go to court on Thursday.
I bet that's early going all that shit out. I tell her that he won't.
Right. I'm going home.
Give me a moment, sir.
I'm telling you.
Okay. Looks like Walmart, Lane Boulevard, large amount of prepaid MasterCards and Visas before taking the men's department where to conceal them in his boxers. Okay, Kelly advised to detain Noel, call police. Noel had taken a total of 22 prepaid cards. Face value $120. Caught on video surveillance. Noel, let me ask you, do you still live on 7th Street in Fort Lauderdale?
Yes, sir.
Okay, I'm going to release you on your own recognizance, sir. Do not go back to Walmart, all right?
Yes, sir.
Thank you. What's your name, sir?
Hugh Harris, sir.
Okay, Mr. Harris. No driver's license, Mr. Harris. Sir, how long have you lived in South Florida?
For 3 years, sir.
What do you do for work?
I'm unemployed right now as a stockbroker.
Stockbroker? What's your?
Yes, I'm a licensed.
What license do you have to have be a stockbroker?
Series 7 and Series 63.
Where'd you go to college?
University of Texas, sir.
Really? Okay. What'd you major in?
Finance.
Wow, not bad. Who's this? This is Mr. Do you have a Texas driver's license?
Yes, sir. I do have a Texas driver's license. I have a few fees that I have to pay off before it is invalid, but I do have one. Yes, sir.
All right. Well, I have an address here, Longwood, Florida. Is that your address?
No, sir. I can give you my current address in Pembroke Pines.
Here's what I'm going to do. I'm going to release you on your own recognizance. You go to the clerk of the court in the next couple days out there in either Plantation or Hollywood and update your address, all right?
Yes, sir. Thank you, Mr. Hurley.
Thank you.
Good afternoon, Your Honor.
Hi, sir. What's your name?
Jacques Terry.
Last name?
Terry.
Terry? Okay. Sir, you're here for theft. Just give me a quick moment.
But you know, like, cause y'all codeine, they gonna.
Could somebody take him back to B5? Is he done? Yeah, he's done. So you wait till they finish. Okay. Thank you.
Yeah, they do your codeine, they don't give you a number for him.
Hey, good. You know what there was five for yesterday? Huh? You know what there was five for yesterday? There was a what? What five there was five for yesterday?
Yeah.
Stupid. For what? Taking his head. The guy was combing his hair over the guy.
Yeah, dumb.
Okay. All right, sir. You know,
I heard
you still live on 21st Street in Lauderdale Lakes?
Huh?
Do you still live on 21st Street in Lauderdale Lakes?
Yes, sir.
All right, sir.
Black is back there with you?
I don't know.
You know little Black?
I'm gonna know what the name of the store
He in
is.
there with you?
He knows. Walmart. Sir, you're not allowed to return to Walmart. Do you understand?
Yes, sir.
I'm going to release you on your own recognizance today. Thank you.
Thank you.
Okay, you're welcome. Who's next?
How you doing this evening, sir? My name is Adesh Prasad.
Boy, when he says this evening, it makes me get depressed, doesn't it? Makes me just been in here all day long. You get here in the dark and you leave in the dark, you know? It's like a mine, working in the mines. All right, Mr. Prasad, you're here for trespassing.
Yes, sir.
Let's see.
Get a lawyer, it's gonna say CI, and they're gonna put his whole name on that thing.
When's the last time Mr. Prasad came in here?
He was picked up in August on a bond surrender on a battery that he pled out and got time served September 4th. Prior to that was 6 days earlier, August 2nd. That was on the battery. I guess the bondsman had to change their heart. July 10th, resisting without violence, open container on the municipal ordinance. November of last year.
So this is his fourth arrest this year. Mr. Prasad, would you like to resolve your case today?
Yes, sir, I would.
You plead no contest, the case is over with. You're not going to have a trial, we're not going to appoint an attorney. Do you understand that, sir?
Yes, sir.
How do you plead to this charge?
No contest,
I'll
sir.
withhold adjudication. Don't go back to the Rip-On Food Mark.
Yes, sir.
Thank you. All right, who's next?
Samuel Torres.
Okay, Mr. Torres. Mr. Torres,
Yes.
you didn't complete community service hours. That's what he's here for. I'm gonna, can I have an order converting community service hours, give him credit for time served, and just let him out of jail, all right? 35 hours of community service is hereby the civil lane. There you go. You're out of here.
Thank you, Your Honor. Have a great day.
Who's next?
Well, sir, how polite, Your Honor.
Okay.
I wish I would've did that. Go.
Yeah, Mr. Hippolyte, theft and marijuana.
Tell Black, say, yo, tell him, hey, Black, you should tell what's up. You don't even know me.
Mr. Hippolyte, how come you've not bonded out of the jail yet?
Sorry, Your Honor, I can't hear you.
Sir, how come you've not bonded out of jail yet?
Right now I'm the only one that's able to work in my family.
You live up in Orlando, am I correct?
Yes, sir.
Well, what are you doing down here in South Florida? In the Broward
I'm
County?
coming down to. I came down to check out the job situation. I'm moving down here.
What type of work are you doing?
Pretty much resort hotels, guest service. I have a minor hospitality from UCF.
Got caught on closed circuit TV. Sir, who lives on Cater Lane in Orlando?
That is my mother.
All right, I'm going to release you on your own recognizance. Don't go back to Sears, all right? Your mom's going to get your mail, all right?
Okay, yes, sir. Thank you.
Thank you. All right, who's next? Anybody else at Conti?
That's it for Conti.
Okay, what about North Broward? Who do you have?
Your Honor, we have McFadden and Martinez.
All right, give me Martinez real quick.
How you doing today, Your Honor?
Hi, sir. Martinez, criminal mischief. Give me a moment. Look here.
Gotta learn that system too. Don't feel like the safety will be able to.
Okay, it says here he's at large in Fort Lauderdale. And, you have a daughter named Allison, sir?
Yes, sir. And as well as a daughter named Brianna, 2 little girls.
Okay. And I'm looking here. It says that, defendant is charged with, defendant and his ex-girlfriend involved in a verbal altercation. And it says that defendant and his ex-girlfriend arrived. Defendant produced a large kitchen knife, proceeded to walk to the listed blue color Chevrolet vehicle, and began to stab and slash at the driver's side front tire. Stabbing and slashing the tire. Defendant's ex-girlfriend observed the defendant with the knife, observed the defendant at the driver's side front tire. Police officer noticed the tire was completely flat and realized it was because there were several large holes in the tire. All right, hold on. Sorry about that, Mr. Richard. Scratches, slash marks, gouge marks on the side. Okay. I guess we get the picture. How come you haven't bonded out yet, Mr. Martinez?
Fortunately, Your Honor, I have no money to bond out.
Well, it's a $100 bond. You couldn't make
It was originally $25, and they actually raised it to $100, and I just don't have the money, Your Honor. I broke my ankle. I lost my job. I'm having a really rough couple months, to be honest with you, Your Honor.
Well, I would say that, yeah, I would probably agree with that. What, I mean, you know, what, does he have any criminal record, anybody know? I mean,
I'll need his BCCN number.
BCCN is 0594437. I just wonder why your ex-girlfriend or some of them didn't come bond you out, you know? Well, that was her tire.
Well, technically, she can't bond yet.
You know.
Technically,
probably lacks motivation, you know? I mean, you figure you gotta replace the tire, that's $150 right there, so. Go ahead, Steve.
He's got, as far as Broward goes, he's got some stuff, nothing too serious.
All right, sir, I'm gonna release you on your own recognizance, but I'm gonna order that you have no contact with your ex-girlfriend or any of her property. Is that clear?
Yes, Your Honor, I completely understand that.
Okay, now, hold on, I wanna make sure that we know who your ex-girlfriend is here.
Rachel College?
Well, I think the car was owned by Stephen Falk. Maybe
Yes, sir. It's actually not her car at all. That's what I was going to say. But
Okay, well,
I understand that to stay away from her and her home and everything like that.
All right, so stay away from your ex-girlfriend or her parents, all right?
Yes, sir.
Thank you.
Thank you very much. Have a great day.
You too.
Thank you.
Okay. McFadden at North. Okay.
Yes, sir.
Mr. McFadden, just give me a quick moment here. I'm going to go to another screen.
I can't get into Odyssey right now.
Okay, I have right here.
Showing it's been filed, but
Sir, Mr. McFadden, it says here on November 18th, 2014, the state of Florida filed a formal charge against you. State of Florida versus Keith McFadden, count 1, possession of PVP. I'm gonna pyrolindinoleurophenone. PVP. Count 2, attempted tampering with physical evidence. Count 3, trespassing on property. That's a misdemeanor. I'm gonna look at count 2. Oops, sorry. We look at page 2. Alex Urella signed the information, the formal charge November 18th. Let me ask the defense, do you have any issues with this, sir?
No, Your Honor.
Okay, Mr. Keith McFadden. Sir,
Yes,
case
sir.
number 14-12760 CF10. The motion to release you ROR today will be denied. All previously set bond and release conditions shall remain in full force and effect. Thank you, sir.
What you mean by that, sir?
That means that the state of Florida, the prosecutor filed a formal charge on you. That means nothing has changed. You're not going to have your bond reduced today. You go right back to your trial judge. All right, sir? Thank you.
the perfectioning not done.
Missy Patrick Ulysses. Patrick Ulysses.
Try to tell you, it wasn't just miss. It was set for the
This
morning.
is
It was
second
supposed
look
to
in
be
30
in the morning. Everything else is second look, Judge.
Well, we don't have him there. We don't have. I'm going to reset him for another day. We have no one else left.
Well, Your Honor, there's one other thing. We had Anton Francis.
Who?
This morning. It was the perfection. I know it was being said that maybe they...
Anton Francis.
They still don't have him, but at this point, I mean, it's been 48 hours, so a determination has to be made.
I'm going to find probable cause on Anton Francis. PC is found. So,
thank you.
Pass that through. No.
Let me check on her.
Oliver Wallace.
I think some might have been deleted.
That's going to go through to the division. All right, he's already got hearing set. Send that to the division. All right, now, I think that's a wrap. Am I correct? Let me see. Let me see, count 2 only. Forget it. Why? He's got a bond for not showing up in court. Yeah, but count 2's a failure to show up, isn't it? Yes, it is. Okay, I find probable cause. No show, calendar call, bonds 500. There you go. Colleen Geary. Colleen Geary. She's got to be held on something else, right?
Who's this on, Geary?
Geary.
Let me check.
Colleen Geary.
I'll check right now. Oh, there you go.
She's not in custody? All right, here we go.
Hello? Hello?
Yes. There you go. Now what? Oh, that was resolved, taken off the docket. Don't worry about that.
This is on
We took
McDonald's.
care of it earlier
We're
today.
all good. We're all good.
All right,
here's what's
everyone.
going on. I'm just give me a second.
I think that's a wrap. We'll see you back
I
here
was really
Wednesday.
concerned because all I
Tomorrow
had at
morning,
first was
8:30
the
in the morning.
original
Until then,
PC.
we're out from room 235. Thank you.
And